try again. Section 7, because I think it clears some space. So, Part 7, Open Justice and Exceptions, Rights to Information from Courts and to Case Material. We need to know 7.1. The fundamental rule, principle in common law is that court proceedings are in most circumstances open to the public and media. That is expressed in Scott versus Scott. The common law exceptions to this open justice principle, the Attorney General vs. Leveller Magazine Limited is also a leading case, in that it states that the departure from the principle is only justified in the administration of justice would otherwise be frustrated or rendered impracticable. The meaning of the term in private as regards a court hearing, and that it encompasses the older terms still in use, in camera and in chambers. Although a journalist may be allowed to attend a hearing in chambers if it is so held solely for administrative convenience, that it is possibly in common law to allow reporters to be in court while excluding the public, usually to avoid disruption by the members of the public. Chambers are when a hearing, usually a preliminary one in a case, is held in the judge's chambers or another room rather than a formal courtroom. In camera, that is when the public and the media are excluded from all or part of the main hearing of a case, and the hearing is effectively being held in secret. In private is used to cover both terms. Rules on open and private hearings is governed by the criminal procedure rules and the criminal practice directions. Rule 6.2 of those criminal practice rules directions say a court must have regard to the importance of dealing with criminal cases in public. And case law, it's been acknowledged that the press do not necessarily need to be excluded with members of the public with reference to rowdy behaviour. This is 1989 Court of Appeal Judgment R vs. Crook. Tim. 7.2. The following statutes uphold or qualify the open justice principle and the essence of their provisions in this respect. Section 121 of the Magistrates Court Act 1980. Read that again. That the following statutes uphold or qualify the open justice principle and the essence of their provision in this respect. Section 121 of the Magistrates Court Act 1980. Okay, Section 37, the children, I think I might want to put this on the different line. Section 121 of the Magistrates Court Act 1980, Section 37 of the Children and Young Persons Act 1933, Section 25 of the Youth Justice and Criminal Evidence Act 1999, including that as regards Section 25 of the 99 Act, the court should permit one reporter to remain in court when the relevant witness gives evidence. That Section 47 of the Children and Young Persons Act 1933 Act states that the public cannot attend youth court cases, but that bona fide reporters can. 7.4. Case law on media rights to know the names of magistrates. Criminal Procedure Rule 5.8 says that media must give names of magistrates, also known as Justices of the Peace. Case law, Fine Court 1987 in R vs. Felixstowe, Justice X.P. Lee. Lord Justice Watkins commenting, there is, in my view, no such person known to the law as the anonymous J.P. Road to Justice of the Peace. 7.5. The rights in Rule 5.8 of the Criminal Procedure Rules, which mean that anyone, including journalists, should normally be supplied by the court officer with the following information about any criminal case which is ongoing or in which the verdict was not more than 6 months ago. The date of any public hearing in the case, each alleged offence, charge, any plea entered, the court's decision at any public hearing, including about bail, or the sending of the case to another court where the case is under appeal, the outcome of any trial and any appeal, and the identities of the prosecutor, the defendant, the lawyer's address, and the identities of the judge or magistrate. That the rules says that the request for these details may be made orally, and no reason for the request needs to be stated. that the rules say that the court officer must also supply details of any reporting or access restriction ordered by the court, but that a request for any other information about a case or details listed above about an older case must normally be in writing and must explain why the information is required, and that the court will decide whether such information will be supplied. Note, the defendant's identity should be construed by the court to include age and address as well as name, and that is important in terms of defamation law. 7.6. That Part 5b of the Criminal Practice Directions says that the opening notes, written submissions and skeleton arguments used by counsel in criminal courts should normally be provided to journalists who want them to report cases contemporaneously. And that other case documents can also be provided to journalists at the discretion of the court, and that a request for access to case documents should first be addressed to the party who presented them to the court, and if that party, for example the prosecution, refuses, the request can be made to the court, and that the responsibility for complying with any reporting restrictions rests with the journalist who receives such documents. There is landmark case law and a victory for the media here. In the Court of Appeal in 2012, it ruled that the Guardian should have been given access to documents used in an extradition hearing. This was R on the application of Guardian News and Media Limited. This is the City of Westminster Magistrates Court, the Court of Appeal 2012. This established a presumption in law that journalists covering hearings in court should be able to see case material to aid that coverage. Part 5b came into force in 2013 and now reflects this. 7.7. That skeleton arguments are used in both criminal and civil cases and are documents in which each side sets out the basis of their case. Pretty simple. 7.8. That if the relevant claim has been listed for a hearing or all defendants have filed acknowledgements of service of defences, or if judgment has been entered, the civil procedure rules normally allow a journalist reporting a civil case to inspect and obtain a copy of the statement of case, which means the claim form. Particulars of claim, defence, and also any counterclaim will apply to the defence. That the rules also normally allow a journalist to inspect during the course of a civil trial witness statements which are evidence in chief, and that the judge in that case has discretion to allow a journalist to see skeleton arguments and written openings used by counsel to aid contemporaneous reporting of it, and that the journalist can, under the rules, obtain a copy of the case's judgment if the case has been heard in open court, which is the norm. Case law, Forbes v. Smith, 1998. Mr. Justice Jacobs said that with very rare exceptions, and even when a hearing was in private, no judgment could be regarded as a secret document. There is a lot of detail in pages 172 and 74 that's not been covered. I'd be amazed if a question looks at this directly, detailed that closely, but it may be worth a separate read. So, Part 8. Challenges to court orders restricting reporting and excluding the media. 8.1. Methods to query or challenge restricted decisions made by magistrates and by Crown Court judges on what may be reported or to exclude the media from a court hearing, and good practice as regards what a court clerk can be asked to provide specified state. An approach to the court by a reporter or editor. Journalists challenging proposed or actual reporting restrictions or exclusions of the media from a court should raise the issue as soon as possible. In court, a reporter should approach the clerk if a hearing is underway, asking an usher to pass the clerk a note. Journalists should refer to the Judicial College guidance. If an order has already been made, a clerk can now be asked to supply it in written form, specify in writing why it was made, state in writing the statute and section under which it was made. And this is if the order's not made these things clear. Such a request might prompt the court to reconsider the order, especially if the query quotes case law against it. Raising a query or challenge in person in court or by an editor writing to the court has the advantages that doing so may resolve the matter quickly and of being the cheapest method, as there is no need to involve a lawyer. Then you also need to know the legal route of taking the challenge to a higher court, that is, application for judicial review or using section 159, and the advantages and disadvantages of each method, which is described on page 181. So, challenges to take to a higher court. Journalists can apply to the Queen's Bench Divisional Court, part of the High Court, for judicial review of a decision by a magistrate's or coroner's court. This normally involves the hiring of lawyers and a court fee (brackets expense). Could also include the costs of any party opposing. Crown Court restrictions can be challenged at the Court of Appeal under Section 159 of the Criminal Justice Act 1988. The disadvantages: the appeal may not be considered quickly. The appeal will involve costs, as above. Part 40 of the Criminal Procedure Rules sets out the procedure for appealing to the Court of Appeal against a reporting or access restriction. Media's right to be heard is on page 178. This mentions Rule 6.23 of the Criminal Procedure Rules and says a court should not impose a restriction unless each party and any other person directly affected, which would include the media, is present and has had an opportunity to make representations. It's also restated in the Criminal Practice Direction 6b.4. This may be over and above what you need to know, but if you remember it and quote it, I'm sure you'll be viewed positively. You also need to know that an invalid order made by a court to restrict reporting must be obeyed until it's rescinded by a court. As said, case law references Lakar Group and Rami versus Al Jazeera satellite channel. McNays references this but doesn't comment on it on the page referenced. So I've looked it up separately. The claimants brought a libel action against the defendants in respect of an allegedly defamatory television program and obtained an interim injunction prohibiting the broadcast of the television or video footage. While the injunction was in force, the defendants continued to broadcast the soundtrack to the program via the internet. The claimants alleged that the defendants were in contempt of court and applied for committal of the second defendant, the Qatar resident Egyptian national, and sequestration of the assets of the first defendant. So it's not specific. So specific evidence here is uncertain, but my understanding is contempt of court was claimed but not held. So, yeah. 8.2. The relevance of Article 10 of the European Convention on Human Rights to such challenges, and it should be quoted in them. So, freedom of expression. Journalists opposing restriction or exclusion should remind the court of their and the public's convention's rights under Article 10. Brilliant. Quick pause and we've got 2 left.